Yes. Yes, call.
My lord, I beg to mention item number 11, my lord. My lord, I'm afraid that the criminal appeal has become infructuous, my lord, because he has completed his sentence apparently.
So it becomes infructuous. If you say that, we will hold it, it's infructuous.
No, my lord, I think not completely.
My lord, I don't think there will be any opposition.
My lord, he has been in custody since 31/8/2015.
It's up to you, you see.
My lord, it has become infructuous.
No, judgment dated.
Okay. Judgment? No, he's in jail since arrest. Since arrest, 31 August 2015.
You are sure about that?
Sure. He completed his sentence, my lord, on 23rd August 2023, my lord. Now, the only thing I may be allowed to come back, because in case he is default in payment of the fine, my lord, he has to serve another 6 months.
No, what do you want right now? You want the court to
I
pass some
need
order?
some time, my lord, so that I can seek a clarification from the jail authorities whether he has paid the fine and completed his sentence, my lord.
Okay. 11. Mr. M. Sharma. Learned counsel for the appellant submits that the criminal appeal might have become infructuous and prays for some time to take instruction.
My lord.
Next week.
Prayer allowed,
You can
Mr.
say
Matter after 2 weeks.
Next week you can submit.
Mr. Khan, you are there in this.
Yes, my lord.
Let him take instruction.
Lordship, absolutely.
Obliged, my lord.
Your Lordship, I would like to mention item number 12 and 13.
Only these two, no other items. Item number 12 and 13.
Yes, sir.
You are for the
For the petitioner, Your Lordship.
Mr. Mahanto, SP Mahanto.
Yes, Your Lordship.
Still not well.
He's recovering, but then he needs more time because it's like giving up.
There must be somebody to take up these matters. These are 2019 matters.
Yes, Your Lordship.
Okay. Item. You have any objection?
In this case, no objection. Your Lordship.
12 and 13. Both will be same order. Okay. Yes. A prayer has been made on behalf of Mr. SP Mahanto, London Senior Counsel, appearing for the respondent number
4.
4 in both the cases,
Yes, sir. Shillong Contentment.
on the ground that the London Senior Counsel is still indisposed. The prayer has not been opposed by the London Counsel for the petitioner. Release this matter after 2 weeks.
Much obliged.
Very obliged.
Lordship, I beg to mention item number 15.
I am the petitioner here, my lord. This is.
You are objecting?
I am not objecting. But after 2 weeks, my lord, we'll finish the matter.
Criminal writ petition.
Lordship,
It's a criminal
criminal
writ.
writ petition, well, challenging the finding of the border security force, the court, my lord.
Two weeks. On the prayer of the respondent. Release this matter after 2 weeks.
Obliged.
Yes.
Your Lordship, I beg to mention item number 14.
Yes, you are for?
Petitioner, my lordship. This matter will come after 2 weeks, lordship. 2 weeks, lordship.
Why?
Personal difficulty, your lordship,
Whose personal difficulty?
of my senior counsel,
Who is your senior?
Mr. Philman Nongri.
I am for respondent number 7.
For the state, Your Lordship.
No objection. This also 2019 matters. Okay. Yeah. On the prayer made by Learned Counsel or the petitioner. This is matter after 2 weeks.
Mr. Batch, Lordship.
Yes.
Main list, item number 1.
Yes.
Your Lordship. Your Lordship, this is the second round of litigation before this honorable court, Your Lordship, wherein the first criminal petition was dismissed as withdrawal.
Your mic is okay. Is it all right? I cannot hear you properly. Yes.
Your Lordship, the first criminal petition was dismissed as withdrawal with a liberty for the petitioner to come before this honorable court as and when she is aggrieved, Your Lordship. Here the case, Your Lordship, the petitioner, she has been appointed as a distributor of the company named Sindor Enviro Private Limited, which is a registered company, Your Lordship, White agreement dated 9 September 2019. In pursuance to this agreement, Your Lordship, the petitioner had entered into an agreement with the respondent number 2 for the supply of SE organic bag, for the supply of 1,000 kg of SE organic bag, Your Lordship, for consideration amount of 5,25,000, Your Lordship. However, Your Lordship, due to absence of go down, the respondent number 2 refused to take the product, Your Lordship. To her surprise, Your Lordship, an FIR dated 6/3/2022 was lodged against
Where is the FIR?
petitioner, Your Lordship. FIR,
Let us see
Your
the
Lordship,
FIR.
is at Annexure 6, page 30, Your Lordship.
Yeah.
May I read, Your Lordship?
Yes.
May I read the FIR, Your Lordship?
The matter has been charge sheeted.
Matter has been charge sheeted, Your Lordship. We have filed a written argument, Your Lordship. However, the learned trial court, taking into considerations White impugned order dated 24/2023, had sustained the sections incorporated in the charge sheet, Your Lordship. For that reason, I'm before this honorable court, Your Lordship.
But then, see, FIR discloses clear cut. Since you have projected yourself something to be, you have projected to be an agent of some company which you are actually not.
There's an agreement, Your
Cannot
Lordship.
be a civil dispute. There may be an agreement, but then you, when your identity itself, your projection, you have acted like an impostor. You see.
But this section does not attract in this case, Your Lordship.
Section can be altered. Section can be altered any time. You cannot basically argue at this point on the ingredient of section for getting it quashed. 216 is there.
Yes, Lord.
It can be. Court has the power to do it before pronouncing judgment. Yes, Mr. Abraham.
I'm little handicapped, Your Lordship.
Why that earlier round of litigation was withdrawn? And why that liberty in a criminal matter? Anyway, we'll issue notice.
Yes, sir.
Hard. Issue notice, returnable in 3 weeks. Mr. H. Abraham, London County Council appears for the respondent number 1, and as such, no formal notice is called for in respect of the same respondent. It responds the same respondent. The petitioner will take steps for service of notice upon respondent number 2 within 2 days.
Oblige, Your Lordship.
List accordingly.
Item number 2.
My lord, this matter can be listed for hearing, my lord.
Can be listed for hearing.
My lord.
The
After 2 weeks, my lord.
parties submit that the matter is ready for hearing. List the matter for hearing after 2 weeks.
Oblige. Oblige.
Item number 3.
Litigation. May it please the Lordship.
Yes.
Malad, this is a matter where I have come for quashing of an investigation. So, Malad, on hand I have a tough case, but at the same time, Malad, I can impress upon your Lordship that the case as such, I rely on two parts to it. I would ask my learned friend to answer on that.
The parties are ready for hearing.
Yes, that's true. If your Lordship takes it up, only issue is, my Lord, there has been no coercive steps. No coercive step is there. The issue is here, my Lord, with due respect to my learned friends and the state, my Lord, this is a counterblast to a case which we had filed in West Bengal. Right, my Lord. Now, what happened? The investigating officer, after 6 months of that case, on the 14th of April 2023, that case was started on the 8th of November 2022. What they have done is, Mala, those documents which are seized in connection with that case in West Bengal, the investigating agency here is asking me to produce those documents here. But that is the issue why we want an early hearing or stay of investigation. Because, Mala, we are being harassed like anything, Mala.
Can it be ground for quashing?
If I may interject, Your Lordship.
One minute. Hear me what he said. Yes, Mala.
Can it be a ground for quashing? That the documents which you have submitted there has been asked for by the investigating authority here.
No. I have not asked for quashing there. I am the complainant there.
No. You are asking quashing here.
I am not asking anything. They are asking me to produce documents which are part of investigation in West Bengal.
Are you seeking quashment of the proceedings?
The FIR doesn't disclose an offence.
Do not get excited. Kindly.
Sorry, man.
I said, please do not get excited.
No, I am not excited. No, that's my normal voice.
See.
I'm sorry, Balan, if you feel I got excited. No. What I'm trying to impress upon you.
Just try to correct me if I do not get you correctly. One of your submission was that, one limb of your submission was that an FIR was filed in Kolkata,
correct,
or maybe in West Bengal, before the FIR, which is under challenge here. Before the FIR, which is lodged here.
No, mine was filed in November.
So that was filed before.
Yes.
This one is after.
14th of April.
So now you are seeking quashing of this one, isn't it?
FIR.
So that is what exactly the court is saying.
Right, man. I couldn't get your Lordship. I'm sorry, man. Lordship, pardon me for that.
Probably there is some difficulty with my communication. Anyway.
Well, don't embarrass me by saying that, man.
No. Anyway, let us not get diverted to this.
Yes, sir.
Now, the submission which you advanced here is that the documents which were submitted by you to the investigating authority there has been asked by the investigating officer here.
From me.
Now, that the query of the court is that whether that can be a ground for quashing.
No, I'm not saying that. That's one of the grounds. But let's accept one thing. Your Lordship, limited scope. Scope is if subject to corrections. Limited scope is I'll read out the FIR. If your Lordship feels any case is made out.
Exactly.
Oh, not. Now, once a case is made out, I'm thrown out of court.
That is what.
So that's the issue. So, if your Lordship wants to hear me on that one, I can do it right now. Or because it is for orders.
That is what the problem is. If it comes up for hearing, the thing is that these are new cases.
Yes, that's 23 cases.
There are many other cases.
True.
Which are pending there. So, as per the High Court rules here, the norm is that the old cases are taken up first. Until and unless, as per the norms which we follow, the High Court rules says that the older cases should be taken up first in the normal norm.
True.
Except in cases where there is exceptional.
No. I don't dispute
now,
that.
if you agree, we can fix it on some other day for hearing. And
yes,
then,
any
as
day.
your Lordship
As your Lordship pleases.
Only they are projecting the case as if it's a blast and a counter blast out here.
That is what
our
the senior
case is
counsel-
very
That is
simple.
we'll see.
That's on merit.
We are only speaking in the air. I'm speaking from my memory, and your Lordship has not come to the documents as yet. Once I think I could impress your Lordship after your Lordship sees the FIR. So, Mal keeps a date as it suits your Lordship.
Go, silent.
You are coming from fee. I am here every day.
Everything.
Or you, I think you both are outstation lawyers, I believe.
I am from Guwahati, my lord. My senior colleague is from Kolkata.
If you can agree on a date, then
agree on a date.
We'll see.
After 17th.
10 October. 10 October?
Is it which day? Which day?
Tuesday.
Yes. Tuesday.
Will be okay. 10th of October.
10th of October. If it is free, your Lordship diary is free.
Okay, we'll say.
10 October.
Hard learned senior counsels. Just take the name. Sorry, I do not know your name.
No, my name is Milord Mukherjee.
I am
Or
Mr.
maybe perhaps you came earlier for arguing some matter. Yes. I saw you arguing before the division bench.
Yes. Well, sorry, Malad, if
I am Mr. Anand Kumar Bhuya, man.
I see you.
AK Bhuya.
Malad, I'm sorry if I've offended your lordship. Malad. I
No,
didn't need to.
no, there is
I
no
didn't
question.
need to.
Do not take it that way. You see, it's a miscommunication, nothing else.
Yes, I'm grateful.
Always in court, thesis, antithesis, synthesis comes in, sir.
Don't take
That is Marxist. This
Nothing of that sort.
I'm grateful. I'm grateful.
This court never takes anything personal. You see, I was on
not at all.
the other side at this court 3 decades.
Yes,
I was
Malad.
lawyer
Yes,
for 3
Malad.
years,
Yes.
30 years. So
we
I
fight
understand.
tooth and nail. But outside
But
the court,
outside we are
we are
friends.
colleagues.
9th of month.
I transfer so.
9th of please. 9th.
As agreed to by the parties, this matter for hearing.
Ninth.
Can it be on the 9th, please?
Ninth.
This court has no difficulty.
No,
So,
Malad, 9th.
Ninth.
this matter for hearing on 9th October.
9th.
So we are fixing it to 9th.
Deeply obliged, man.
Grateful. Grateful.
Item number 4.
Yes.
This is that matter under 482, Lordship, where Section 323, charge sheet have been filed beyond the period of limitation. And cognizance was taken after a period of 2 years. Now there are other sections under the JJ Act, where I have indicated to the court that JJ Act is not applicable. And I don't know, today you were supposed to bring some records. This was the last submission on the last.
My lord, because it's a trial matter, my lord. My lord, this
The matter,
honorable.
the trial is going on.
Yes, my lord.
It's charge sheeted already.
Yes, my lord. So, my lord, my humble request: this honorable court may call for record, my lord.
Why should we call for records? Calling for record is stalling it. This prayer should not come from your side at least.
That is true.
Do you want this proceeding should be stalled?
That
Until and unless there is something prima facie, we will not call.
my lord.
Normally, that is not the law.
My lord.
Disturb the proceedings.
My lord is correct.
You could have brought at least some copies. That was their last.
No, what is the thing? You see, like what would be your ground of argument? Now it depends upon whether we need something or not. It depends upon what you argue.
According to me, we don't need.
So then,
Whatever there is on record.
on the you see, the last order doesn't say about the production of anything.
Listen to me.
Nobody is appearing for S1 number 5. S1 number 5. Nobody is appearing.
Whether they filed the status report, my lord, copy is served or not.
It has already been filed. You please check the records before you appear. That is your duty. The counsels are there to assist the court. It's not for the court to assist the counsel.
My lord.
So we'll take it up for hearing. When? 2 weeks.
Okay, Your Lordship. Because I suggest we have sought for time from the trial court, so charge have not been framed till date.
So this will. Is there any interim order?
There's no interim order, but we have informed the court that we are challenging that order of direction of framing of charge under JJ Act. So that is sub judice. So the court also did not frame charge. We are not at the stage of charge having been.
That is up to the court there, trial court actually. Otherwise, there is no bar for the court to proceed.
There's no bar, but that is the very action of the trial court is under challenge.
And hard. Just give the things. The matter is ready for hearing. According to list, it for hearing after 2 weeks.
My lord.
Actually, record why is not required, Your Lordship, because it is absolutely on the provision of law.
And if it is on the ground of law, as you say,
Law.
as say for 323,
No,
you
I'm
say
not
limit.
speaking of merit at all.
So that is what. See, 482, I don't think so. Actually, unless you say that there is nothing in the FIR.
Yes, Your Lordship, because according to me, whether JJ Act is applicable or not, that is to be examined. And whether after 323 says that charge sheet have to be filed within a period of 1 year. And cognizance has to be taken within a period of 1 year. But it took beyond 1 year.
If we confine ourselves only to 323. But if you take into consideration of JJ Act, then period of limitation will not apply.
JJ Act, we are saying that it's not applicable.
You are saying it, we have to see how much.
Much obliged and good day, Your Lordship.
Obliged.
Item number 5.
The respondents wanted to file an affidavit in this case, my lord.
Lordship, I pray for some more time to file affidavit.
What is this matter about?
My lord, I am challenging the. My lord, this basically is a criminal complaint filed under the Drugs and Cosmetics Act. The petitioners before the court are directors of a company, my lord.
So you are praying for quashing of the proceeding?
Quashing of the entire proceedings. My lord, I say that, well, I am not liable because I was not directly involved in manufacturing of the drugs. And also because, my lord, the company has been on the administrative side been punished. My license was suspended for a day. So, my lord, after that, whether the criminal proceedings can be taken up against me or not, that is the question to be decided.
So what is the stage of the proceeding?
Well, I have not pressed for stay because the trial court has been quite lenient. Matter is fixed in the month of November. So, well, by before that, I think probably affidavit will be filed and matter can be taken up for you.
So there is no requirement of passing of interim order by the High Court?
I have not pressed, my lord. That
so
is why.
the trial courts in the other matter also have been told. Mr. Kinta's matter.
See, the trial court has been lenient. The trial court has understood I have approached this court, and trial court has also seen some substance in my application.
Well, respect for by Ms. Pradhan, learning counsel for the respondents. Further, see, earlier also you have been given time twice.
Lordship, we have sent the affidavit for signature, Lordship.
And in criminal matter, what affidavit?
Affidavit actually, exactly. But then since they want to file,
you make the file bulky. There is no use. 482, you will have to stand. You see, you hardly have any. Until unless there are some
records may be called for at the most if required.
Yes, and until unless there is some factual assertion. I don't think. Anyway, that's what so and so. Another 2 weeks' time is granted for filing the affidavit. For filing an affidavit, for filing what affidavit it was?
Well, generally, but since they have prayed for it, was allowed earlier, so I have not.
This is a kind of objection. You are bringing in objection.
The only thing is trial court records may be called for. Apart from the
If it is
records, we
required,
cannot
if
go
it is-
beyond that.
If it is required, we will not.
If it's
call for
required, well,
records
I am
of
also not
this.
pressing for that at the moment.
What is it? For filing affidavit in this matter. We are not saying anything else. But then
Generally, in 482 matters, we don't file affidavit.
sometimes objection comes. If it's
Sometimes
they can.
if
They have
to bring something which is contrary. Perhaps they will. So I have no.
You may make some statement which is not correct.
Absolutely.
Then if they wanted to. Otherwise, normally not.
Hardly.
Fine.
Obliged.
After
Highly
tips.
obliged.
Item
Yes.
number 7.
Wait, please.
Yes.
Lordship, I am before this honourable court for quashing of session case number 17 of 2017. That is pending before the court of the session judge Joy.
This is for quashing.
Yes, yes. Ma'am.
What quashing of POXO case?
Not POXO cases.
It is
The matter is under section 326 and 307 IPC.
on the basis of compromise.
Yes, 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 madam.
So we'll take it up for hearing.
Yes, madam.
Let it be listed for hearing.
Yes, madam.
This is not in the hearing list. No? It
is in the order list.
It is in the order list. We'll get it. Because this way you see new cases are getting priority and old cases
Yes.
are getting
We can take it up on the next date, Your Lordship. If Your
we
Lordship.
will be getting it. We will be listing it for hearing and let's we'll see.
Yes, yes.
Because in this case, the trial is proceeding, my lord. So if
Criminal
that
matters
is not-
where almost all matters are trials are proceedings.
Yes, my lord.
Criminal cases, almost all matters trials are proceedings. We'll take it up for hearing after 2 weeks or something.
Yes,
like that. This hard parties. This is matters for hearing after 2 weeks. Because the court is developing a habit of taking up matter and disposing it in order columns. This is something very wrong. All the matters which are in the hearing column is getting ignored. Okay. That is a problem. And normally you see the cases, this court hardly sits for the whole day. So if once it is in the hearing list, if you want, if the counsels are present, we can always take up a matter and dispose.
Yes, yes.
Blush.
Blush.
Hearing item number 9.
Please, my lord. Please, my lord. My lord, on the last question, senior counsel has submitted that settlement cannot be arrived at, my lord.
Yes.
And my lord has posted this matter for hearing.
Yes.
And Mr. Paul is leading us in this matter, your lordship.
Yes.
I'm praying for some accommodation, your lordship.
The problem is that you see these are all old cases. This is a 2014 matter.
1 week.
2014 matter. The order sheet has become much more thicker than the petition itself.
My policy, your lordship.
Okay. And it is, I do not know what for, I have not gone through the entire order sheet. But then presumably it is because of this offer of this thing, compromise and all those things. So why to keep things unnecessary pending like this?
Lordship, kindly allow 1 more week, your lordship.
This is something not very correct way of proceedings. Salary for, what is a non-payment of salary, and it is for period of how many years?
Only few months, lordship.
Few months.
Yes.
And matter is pending from 2014 for the few months salary.
And you see, there's a dispute between there's a original school and fictitious school, lordship. That's the main issue. Terminated since 2000.
It's okay, but then if his claim is with regard to the salary for the period which she served,
Yes,
then
She is entitled.
she is entitled. And then
She is entitled that period per year she has served. That much though she has to be paid by the management.
so this is not an aided school. It's an aided school.
Aided school.
And she is working in a sanctioned post. She was working or whatever it is. She
Was working.
The claim of salary is in respect of some sanctioned post.
No, your lordship, before termination, there are some money release of salary only for few months. It's lying with the then secretary who expired, your lordship.
No, but then the salary is basically who pays salary? The government. Government transferred the money to the managing committee. So it is the state who pays.
Yes, yes.
So state has done discharged its duty, isn't
Yes,
it?
yes.
Now only the managing committee, the then managing committee or whoever it is,
Yes, sir.
has not paid. That is the case.
They were linked
So
to
you see, like, so since there was a talk of compromise, in
Yes,
this
sir.
matter, so it is assumed that you agree that some outstanding salary is.
Yes, lordship, is pending with the then
But then what is the rate? That is the dispute.
Yes, lord.
Now, if the rate is disputed, on what basis court will determine it?
Yes.
Was there a Pascal? And on what basis? What would be the criteria for determining the disputed amount?
The dispute amount.
Say, supposing if she claims 5,000, you said no, it is 4,000. How this court will give a finding? What is correct?
Do you say like because she said like she's still working, your lordship, but she has been terminated in 2003, your lordship. So after 2003, also she's claiming her salary, your lordship. That's the dispute.
Anyway, we'll take it off.
Okay.
Let's wait for the line counsel for the petition. This is matter after a week.
Right.
We'll not adjourn it any further. Next year. Next week.
Oh, bless you.
This court will reassemble again.